नीरव,
Yes.
म्यूट अनम्यूट तेरे पास से कर लेना.
Right. Good morning, everyone. Thank you. We've
Good
logged in,
morning.
and there are almost 60 of us which are already joined in.
Okay, good.
So, friends, we will
Yes.
soon just wait a few more minutes before we begin the session. Thank you, everyone. Before we begin, we'll just have a few points of to be noted. With regards to the webinar, I'm sure everyone is well familiar with now. So once, if there are any questions, we have the Q&A section here, where you can pose any questions when with regards to the topic that our speaker is going to be presenting on. We will also have some Q&A live question options available at the end of the session as the time would permit. To have any questions to be asked live at that point of time, we have the option of raising the hand, which you can please utilize through the Zoom platform. President sir, we are almost 70 attendees now, and it's 11:05. Please let me know when we can start the session accordingly.
Just 2 minutes and we will start.
Thank you. So, good morning once again. This very happy morning to each one of you all. And on behalf of BCBA, I'm very happy to welcome each one of you all on this significant and noteworthy day, which is BCBA's Founders Day. And so, let's understand that what is so important about this Founders Day. It is a day when everyone who had a dream, had a vision, which they brought it to reality, and that is why there is this significance of this day, and it's a celebration for each one of us. We are all proud to be a member of this prestigious institution, and on this momentous day, BCBA has planned for its members a very important and significant topic knowledge series webinar. So, without me spending much time, I would like to have our president, Mr. Kiran Rambia, sir, to address all of us, and then we can take it forward from there. Thank you. Kiran, sir, over to you.
Thank you, Nirav. Good morning to all. Good morning to all the board of advisors, seniors, my past presidents, managing committee members, and members of the association. And of course, our respected Sri Girish Nadkarniji. I welcome you, all of you, on this auspicious day, that is 84th Founders Day. It is my honor to be part of this 84th Founders Day of BCBA. BCBA has seen the proud past, and I'm sure we will see a great future. Thanks to the founders and past presidents who made this association so strong. All the past president and advisor has kept the association united, kept all the members united, and at the same time, all members always stayed together and show the solidarity by staying united. Friends, we all see the speedy changes in our customs clearance work. Day to day, we are finding a new change, and we need to keep ourselves updated for this. Currently, we are into the, we can say, contactless, uh, paperless, and faceless assessment. This is increased our level of scrutiny and monitoring. In this faceless scenario, the post clearance audit will be an important one. Accuracy and declaration and the data feeding being made at the time of submission has become very important, and with implementation of post clearance audit, the role of custom broker has further enhanced. We have to update it for all this thing. Now, on this auspicious day, we BCBA present knowledge session on PCA for enrichment of our members. At the end, very proudly, I acknowledge and appreciate the CB fraternity, our entire staff, the way we CB have withstood the turbulent phase, COVID-19, and discharge our duty diligently for the country. With this, I conclude. Once again, I congratulate each and everyone, all of you, on this 84th Founders Day. Thank you very much. Thank you very much for attending this. Over to you, Nirav.
Thank you, Kiran Bhai. Thank you for this motivating talk for all our members.
Thank you.
Kiran sir,
I think some of our board of advisor or past president must be here. So
yes, we have Mr. Mark Fernandez.
yeah, I request Mark Fernandez to deliver some few words.
Yes. Good morning, Mr. Mark. Are you able to?
Hi, Nirav.
Hi, good morning.
Morning. Sorry for not being on the video because, I'm not in the town. I'm not in town. First of all, I would like to say my heartiest congratulations to BCBA celebrating its 84th Founders Day. As rightly said, Nirav, BCBA, or the Bombay Customers Agent, which was created by all our senior and past colleagues, was with one aim and one goal, and that was to unite. As 84 years ago, they realized in unity we have strength. By being individuals, we lack the ability to withstand the pressures and the forces that work against our industry. I am truly proud to be a part of BCBA. I'm truly proud to see how BCBA has grown and to see you youngsters take over the reins and take it to greater heights. It is with these words that I truly am blessed to see all the youngsters, which actually I had doubts when I was the president, as what happens to the future? Would the young guys appreciate and take this old industry forward? But I am blessed and I'm truly very happy. And once again, convey my hearty congratulations to all of you and to all the young generation that's joining our fraternity, which is actually amazing to see that there are so many young ladies, young girls who have joined, and it is a great achievement for BCBA and to all of you who work selflessly, who work honorably, despite the brickbats thrown on you and by the various authorities and vested interests. With these few words, I convey my hearty congratulations to President Kiran, to his entire team of young, dedicated colleagues who work for the unity and the overall benefit of our trade. God bless you all. Have a wonderful, and I'm listening to the webinar.
Thank
Bye.
you. I think, Nirav?
Yeah, thanks, Mr. Mark. Thank you so much. We are just following your, your teachings, and your blessings are with us today. It's great for us on this. Thank you for taking the time out today, out of your schedule. Really
Thank you for inviting me. Thank you.
Thank you. Thank you, Mark.
Thank you, President.
Om Prakash is there?
Yes, sir. Mr. Om Prakash ji, are you able to hear us?
Hi,
Hi.
Yeah.
I can hear you.
Okay. Yeah,
Yes,
we request
Om
you to
Prakash,
kindly.
I'd like to hear a few words from you.
Yes, sir.
Om Prakash ji. Nirav, I think connectivity
Yeah.
problem.
No, he's just connecting one.
Okay.
Omji, are you there? I think it's getting connected and disconnected.
Okay.
I think you can come back to this.
All right.
Yeah, Nirav will come back to him after.
Okay. We also have Mr. Surab Engineer in.
Definitely would like to hear some you.
Okay. Saurabh sir.
Good morning, Mr. President. Good morning,
Good
friends.
morning.
It is a real pleasure to be addressing the association after 45 years of being associated with them personally as a young teenager. I have seen the association grow from strength to strength, and I'm really proud at what we've been able to achieve. There was a time when we were considered as mukaddams and dalals. Today, we are considered as a very important logistic player in the entire scheme of things. The association has really front in this endeavor. I'm also echoing the sentiments of my of the past president Mark Fernandez, who became president after me, in saying that it's really a proud moment to see you youngsters taking such a firm stand and expressing yourselves so lucidly from time to time and taking on this mantle of training course, which was started many years ago with a very few people. And earlier I was a student, then I used to speak on the podium at that time, and now I'm patiently listening to what the future has to show us. One thing I would request the president and all your managing committee members and all the members of our association to do is hold your head up proud, because you are an absolutely integral part of logistics, without which the wheels of, of commerce will not turn. It is an old saying that if you want to be in any exit business, three people are most important. One is your banker, two is your insurance agent. People forget that. It's very important if you want to remain in business. And three, and most important, is that small, very humble, yet a very important cog in the wheel, the custom broker. We used to call ourselves clearing agents, then custom house agents, and now we are custom brokers in alignment with all world custom brokers. And with these words, I really wish the association great a greatness that it should follow, and best wishes. Thanks.
Thank you. Nirav?
Thank you, Saurabh sir. Thank you so much for pointing out about our trade, about our importance as well. Thank you, really appreciate. Uh, Kiran sir, I think Mr.
Yes.
Om is not connected again, so maybe we can
Okay.
try to
On later stage.
later stage we will connect.
Yes. Is
Okay.
there any other?
I can't see any further right now, sir.
Okay, no problem. So we go ahead and
Okay.
go ahead for further the thing.
So then I think, sir, I would like to ask our Vice President, Mr. Sanjeev Harale, sir, to have our guest speaker today to introduce him, and then we can start with the main session, sir.
Yeah, thank you, Nirav. Good morning, friends, Board of Advisors, past presidents, managing committee members. On this auspicious occasion of BCBA Founders Day, we are fortunate to have with us eminent advocate Sri Girish Nadkarni. Mr. Nadkarni sir has worked in customs for 25 years in various positions. He has worked as Assistant Director DRI before opting for voluntary retirement. He has worked in corporate as Senior Vice President Indirect Taxation and Vice President Legal for almost 11 years. He has been practicing as a lawyer since 2016. Friends, in today's context with faceless, the post-clearance audit has also become very important. Hence, it is necessary to understand the nuances of PCA, since after clearance of consignments, considerable notices are being received by members. Further, Mr. Nadkarni sir will be sharing few important measures and case laws for custom broker protection. Over to you, sir, Mr. Nadkarni.
Good morning and congratulations on the 84th BCBA Foundation Day. And I wish all the best to you all managing committee members as well as the advisors as well as other members. We have a very fruitful 2021 and nice year ahead. Today in the webinar, I will be touch basing on certain requirements under post clearance audit. Can you hear me? Hello.
Yes, sir.
Yes, sir. We can hear you, sir.
Especially in the context of some changes which have been made to audit part by virtue of introduction of audit section 99A to the Customs Act and post clearance audit regulations 2018. As you all are aware, like each coin has two sides, heads and tails. The assessment under the Customs Act also has two sides, basically classification of goods and valuation aspect. Because when the duty is charged under section 12, basically these two aspects come into play. It is the responsibility of the importer to declare the goods correctly in terms of invoice, because assessment integral part of the assessment is valuation of the goods and classification of goods. What happens is in 2011, the concept of assessment has undergone paradigm shift. Earlier, it was the assessment made by the custom officers. Now the onus has shifted to the importers because the customs has introduced first amendment to section 17 and introduced in 2011, April 2000, concept of self-assessment. Now, as a result of self-assessment, the onus of declaring the goods correctly and classifying the goods correctly, submitting correct valuation has shifted to the importers as well as the exporters. Consequently, in 2011, certain changes were made to section 17 and OSPCA regulations were introduced, on-site post-clearance audit. However, in the course of time, when the trade facilitation was increased and it was felt that the trade facilitation can be better achieved by doing away with concurrent audit and other things, the onus shifted to legal framework, transparency, and other aspects related to the assessment. It so happened that in 2018, the Custom Act section 99A was introduced, and along with that, post-customs audit regulations were made by the CBIC. Now, this post-clearance audit is based on global best practices as per the WTO Convention for Facilitation of Trade. It is voluntary compliance culture which helps department for facilitation of trade. This is a shift from concurrent audit to a post-clearance stage, especially keeping in mind that the concurrent audit also used to involve some sort of delay. So, next, this section 99A, after it was incorporated under the Customs Act in 2018, the concept of audit shifted from transactional level to a framework comprising of legal, comprehensive, and statutory requirements. Now, considering that the customs audit is going to play a very important role in future in the context of trade facilitation, there are many aspects which has to be borne in mind, especially by the importer as well as by the exporters. What this regulation, customs audit regulation under section 99A has brought into picture is they have defined the concept of auditee. Auditee has been introduced, and they included in the definition of auditee custodians, licensees of warehouse, customs brokers. Basically, the customs broker per se is not a word which is used in the section 99A, but they have used a broad word in the definition which says any other person connected with clearing, forwarding, stocking, etc. of the imported or exported goods. As a result of this, they have made complementary change amendment to section 17, section 17(2), and introduced the ambit of assessment has been broadened from assessment to duty of assessment of the entries made under section 46 or section 40 and self-assessment of goods. Earlier in 2011, it was only restricted to self-assessment of goods. Now, the auditee has to ensure that the audit can also be performed in relation to entries made under section 46 or section 50 of the Customs Act 1962. So what Customs Audit Regulations 2018, what they solicit and what they expect in the context of these changes is the section 76, which was earlier there, that has been omitted, and this OSPCA rules, regulations which were brought after the self-assessment was introduced, that has also been superseded. The concept of transaction-based audit and premise-based audit has been prescribed, as a result of which not only the audit officers can audit the bills of entries from their office, they can also, with the due notification to the auditees, visit the premises of the customs, of the importers or the customs broker for carrying premises-based audit also. Now, under section 99A, the scope of audit has been widened, empowering the customs to review all import and export under a given period, check all relevant commercial records, check financial statements and contracts, and verify particulars mentioned in the goods declaration. Now, checking of financial statements and contracts, etc., would be a debatable issue, and if need be, we can deliberate it later on. But at the moment, the Customs Audit Regulations 2018, they empower the proper officer of customs to review the assessment at the time of post clearance on a very broader platform. Next. Now, what are the obligations, basically obligations of CB under this Customs Audit Regulations that we need to know? It is basically to comply with the Customs Audit Regulations. Then secondly, to cooperate with the audit team appointed by the customs. And thirdly, to render assistance to the proper officer to discharge their duties. Now, while examining the responsibility of the CB in the Customs Audit Regulation, the CB is required to maintain the record of import and export of documents for a period of 5 years. The regulation stipulates that if the CB does not maintain or is found not to maintain the record for 5 years, then penalty up to 50,000 rupees can be imposed on the CB. Now, the after effect of this is also detrimental to the interest of the CB in the context of CBALR 2018, because under the obligation 10J and K, it is mandatory that documents have to be, import and export documents have to be maintained in a proper way, at least for a period of 5 years. So what happens is, if any, in the context of customs audit regulations, if any non-compliance is observed, or if it is noticed that the records have not been maintained for 5 years, the another set of action that could be initiated against the CHA is their exposure to CBLR 2018 for breach of regulation 10. This we should bear in mind as a customs broker. Then, as a result of these new changes made, they have also introduced Bill of Entry Electronic Integrated Declaration and Paperless Processing Regulations 2018 and Shipping Bill Electronic Integrated Declaration and Paperless Regulation 2018. And if you read these regulations, there also it has been observed that any contravention of these regulations will lead to penalty which may extend to rupees 50,000 for any contravention. So what happens is, as a result of this paradigm shift, the importer as well as the CB has to ensure that the data is properly maintained, the e-Sanchit is properly filed at the time of clearance, and it is preserved for a period of 5 years. Because any at the audit stage, post audit stage, if any deviation is found in the course of audit, then there are certain provisions which under these regulations which unnecessarily will invite action under CBLR also, which we should not forget. Next. Consequently, now audit, ultimately the audit is related to recovery of duty, if any. So it is directly linked to section 28 of the Customs Act. Now, section 28(1) of the Customs Act was amended in 2018 to introduce one proviso to section 28(1), which requires that before any notice is issued under section 28(1) for short levy or short recovery, the pre-notice consultation has to be done by the post audit with the importer in a time-bound manner. So it has become very necessary that before, as opposed to this, earlier the moment audit used to come across, there is a case of short levy, they used to issue notice straight away under section 28(1). Now the act, in terms of this proviso, warrants that the post audit officer will give you an opportunity of consultation before the same is converted into a regular show cause notice. Now, with the introduction of this pre-notice consultation, one more avenue is available for the importer as well as the customs broker to convince the audit department that there was no short levy, or if there is any short levy, then they, under section 28(1)(b), they can voluntarily go and pay the differential duty along with the interest, and thereupon the section 28 provides that no notice shall be issued to the importer. Next. Do you have any questions on this? Whether we will be taking it in the course of question and answer this thing, or you will?
Yes, sir. We shall be taking all the question answers once the presentation is completed.
Okay.
And this current slide, this is just like an index of all the case laws that you will be taking up.
Okay. No. Now I will be proceeding to the CBLR related certain case laws which have been landmark case laws which have been frequently relied upon by the advocates, various advocates, while defending the uh, cases of breach of CBLR regulations or etc. Now, the first is related to due diligence. The due diligence, many a times it is noticed that the proceedings under CBLR are initiated against the customs broker, alleging failure to exercise due diligence. Now, this aspect is more or less settled by the order of Delhi Tribunal in the case of G&D Cargo Movers versus Commissioner of Customs, New Delhi. It is a reported judgment in 2017 357 ELT 1184, which says that any charge of due failure to exercise due diligence has to be established in a nutshell if it is proved that the customs broker had prior knowledge of malafide by the importer or exporter in declaring or misdeclaring the goods. And that's why it is very, very important that whenever any document, bill of entry is filed, the bill of entry should be filed on the basis of the documents provided by the importer or exporter, and the declaration has to be made on the basis of the invoice, as per the invoice. In that case, what happens is, most of the time, if the declaration is made as per the invoice, the court or the tribunals, or to some extent the appellate commissioners also, always absolve the CB if any such charge of failure to due diligence is made against the CB. Next. Well, recently, in the case of Fair Deal Shipping Agency Private Limited versus Commissioner of Customs, it is also a reported judgment 2019 TIOL 990 Sistat Mumbai. It was basically held that the determination of rate of duty or ascertaining eligibility of exemption, etc., it is not the basic responsibility of the customs broker, because there is no such delegated legislation which empowers the CB to declare the goods, because this empowerment lies only with the proper officer, and as such, if any classification is found to be incorrect, or if any declaration is made whereby exemption from duty is sought, which is not due to the importer, the CHA should not be held responsible for penalty or for losing the license. Basically, again, what this drives a point is, we have to go by the correct declaration as per the invoice and leave the rest to the customs authorities. But if I am careless to declare the description properly in the import bill of entry or in the shipping bill, then unnecessarily I will get dragged into the and I will invite proceedings under the Customs Act or under CBLR. Then another thing which next. Most of the times what happens is, wherever the diversion of goods takes place, it has become a fashion to charge the CB for misdemeanor and initiate proceedings against the CB. So this case is no more res gra. It has already been decided in the case by the Supreme Court that the duties of CB and functions of CB comes to an end with the clearance of imported goods and delivery to the owner. And the customs broker cannot be treated as an agent of the importer for all time to come. Now the concept of agent, the custom house agent is granted license under section 146 and not under 147. Now the difference between 146 and 147 is that 147 is a responsibility between agent and the principal, and that section, if any person operates under section 147, then it could be said that the responsibility of the principal lies with the responsibility of the agent, and the proceedings could be initiated against the agent. Whereas the difference between this thing is customs broker is granted a license under section 146. Therefore, he has a limited liability. The custom house agent has a limited liability, and his responsibility comes to an end after clearance of the imported goods. This aspect also has been more or less settled in this Aspinwall case, where Honorable Sister very clearly said that CB is not an agent under section 147 of the Customs Act and not responsible for short levy. Because many a times you must have encountered that if the importer is not traceable or if importer is not cooperating, then the earlier days customs officers used to demand the short levy from the CBs, and they were many a time forcing the CBs to pay the differential duty. This aspect has been dealt with in this Aspinwall case, and as a result of this, the CB is not required, or he cannot be compelled to pay duty. Of course, while I say so, we need to do all sorts of KYC to ensure that tomorrow it should not be a case that the CP filed the bill of entry or the shipping bill on the basis of ghost party. Once you deal with KYC related aspects, and thereafter supposing the importer or the exporter is not available for recovery of duty or for any other purpose, the customs authorities cannot coerce the CP to pay the differential duty in the event the importer is not available or has not presented himself to customs for any further action. Next. Recently, there was one more case which has come to the notice of Sistat Mumbai, where there was a diversion of goods. The goods were cleared under concession of duty, and the custom and the departmental authorities were holding the CHA responsible for diversion of goods, and his case was processed for penalty. The Sistat observed that in the absence of any evidence to link the customs broker with the diversion of the goods, no penalty on the CB could be imposed under section 112 of the Customs Act 1962. There are further certain decisions which relate to basically what is the responsibility of the CB towards the classification or valuation. Basically, these cases are coming up because after the self-assessment, the department had issued some public notice saying that even this customs broker is responsible for valuation as well as classification of the goods. So because this has come after the self-assessment, because the self-assessment puts the whole onus on the importer, and having handled the job on behalf of the importer, the CB also to some extent was being implicated by the department. In this case, Brijesh International, this issue came up in one tribunal case before Delhi tribunal, where the tribunal very categorically held the responsibility of the CB is not to investigate and find out correct classification or value of the goods, and they merely go by the information provided by the importer. Accordingly, the penalty imposed on the CB under section 112 was dropped. Hello. Then another case was also, there is another case of Him Logistic. There also the Delhi tribunal has categorically held that for declaration of classification, no penalty can be imposed on the customs broker. But this fact underlining is, as a CB, I have to declare the goods correctly on the basis of the documents provided by the importer or the exporter. All these decisions will come to the rescue of the CB, provided I am vigilant enough to declare the goods correctly. Currently, there are some chaos which we hear that as a faceless clearance scheme was introduced for facilitating smooth and speedy clearance of imported goods. However, the clearances are in fact delayed inordinately, thereby leading to payment of excessive demurrage and detention, etc., apart from loss on account of opportunity costs. Most of the queries which I hear are in the relation to correctness of transaction value, and therefore there are few case laws which could be quoted as a reply to some wavering queries by the departmental authorities to say that as the transaction value has to be basically considered, and the transaction value can only be rejected if there are contemporaneous imports of identical goods or similar goods at a higher value during the period of say 90 days, because valuation rules provide for time limit of 90 days for the comparison of value. Now I shall deal with those cases under the valuation. So there is one. There are rather three cases which are of some importance in the current scenario of faceless where valuations related issues are continuously recta. One case is decided by Supreme Court, Century Metal Recycling versus Union of India. I'll read out the synopsis of this case. The grievance was brought out by the appellants that the officers of customs were routinely rejecting the transaction value of the goods, insisting on appellants to pay customs duty on valuation adopted by the customs on the basis of valuation alerts issued by the department, and also compel the importers to forego the right to provisional assessment under section 18. Because what happens is, many a times to avoid the incurrence of the demurrage, the importers or the CBs, they request the assessing authority that you at least consider the provisional assessment, let the goods be cleared, and then we shall deal with the matter. In this case, the department was neither allowing the facility of provisional assessment nor finalizing their value. They are forcing them to take the value as per some valuation alerts. Now our DOV department, or there are some standing orders issued. Normally the customs brokers dealing with plastics, dealing with plastic granules, etc., they would be knowing that the customs department normally goes by the plat valuation based on the plat catalog. Now that plat catalog is normally used to defeat the declared value, and in that context, some standing order has also been issued by the department. And still, I have noticed that many a times the declared value, transaction value is being rejected on the basis of flat. Now, the Supreme Court in this particular case had an occasion to deal with such valuation alerts, and they have underlined the fact, they have rather observed that the DOV alerts, the Department of Valuation alerts, they may provide as a guidance in valuation, but they cannot interfere with the discretion of the assessing authority. Basically, what it says is, if the transaction value is to be rejected, then under rule 12, then what you need to know, what you the departmental authorities need to know is what was the value of these similar or identical goods at the time when the goods were imported. Generally, if the higher transaction value is higher value of the similar or identical goods is noticed, then only recourse to rule 12 can be taken and the declared transaction value can be defeated. So whenever any queries are raised regarding genuineness of the transaction value, one has to, the CB will do a great favor by quoting this decision and saying him that you have to go by the declared transaction value, and if by any way, if CB has record of previous imports, then that can be uploaded on e-Sanchit to satisfy the query regarding valuation. Next. This was the first, this Varsha Plastics was the first issue when the Supreme Court very clearly observed that valuation is the discretion of the assessing authority, and the valuation has to be taken, considered, the transaction value has to be accepted in the absence of evidence of higher contemporary import. And in this particular case, rather this was the first case where the value based on plat was rejected by the Honorable Supreme Court, saying that it has to be, the transaction value has to be accepted. Next. Now, the South India television case is also very important, because in this particular case, the Supreme Court says that the invoice value, the invoice cannot be rejected without any evidence of higher price around the same time. So all these three decisions, they very categorically say that in the absence of higher evidence of higher price around the same time when the goods were imported, the declared transaction value has to be accepted by the customs authorities. So whenever any issue is raised regarding valuation, we can always quote these three decisions. And the query, and my experience is in most of the cases, the queries have been withdrawn and the assessments have been, the bills of entries have been cleared by the customs authorities. Next. Further, this means you must have observed that as a matter of routine, after this pre-consultation rules were notified, many a times the audit is also issuing the show cause notices where they notice that the classification has not been correctly claimed by the importer, or where the exemption has been claimed but it is not eligible. And in such a cases, the audit show cause notices are proposing penalty under the Customs Act and liability to confiscation under Section 111. This issue in the post self-assessment period, and this issue came to be tested in the case of Levec Air Shipping Private Limited, where the tribunal observed that for even if the classification claim is incorrect, or even if the exemption claimed is incorrect, so long as the goods have been declared correctly, the misdeclaration cannot be alleged against the importer, and there can be no confiscation of the goods under Section 111. And the tribunal dropped the proceedings under 112 and under 114 AA. 114 AA is a penalty for manipulating the documents, etc. In this particular case, the department filed appeal before the Supreme Court, and Supreme Court has since dismissed the appeal filed by the department, thereby giving finality to the issue that even if I claim ineligible classification, or even if my exemption which I have claimed is not correct, is found out to be incorrect later on in the course of audit, so long as I have declared the goods correctly in the bill of entry, no penalty can be imposed on the importer. The case laws are also stated, and what is to happen is many a times after initiating the proceedings for misdeclaration against the importer, side by side the show cause notices were also implicating the customs broker for their failure in declaring the wrong classification, for in their failure to declare the correct classification, or for claiming the ineligible exemption. If the importers are getting immunity by virtue of this order, automatically no charge of penalty is sustainable against the customs broker in such matters. Now for the suggestions for the customs broker is, basically when you are preparing the checklist, kindly prepare the checklist strictly in accordance with the import or the export documents. Without fail, the checklist has to be approved from the client, and keep record of that, because if you are not getting the checklist approved, many a times the allegation to the account of CB, we find it very difficult to sustain, because this is the procedural aspect which it may be impracticable, but still, at least once you prepare the checklist, get it okayed, then you file whatever your declarations. You have to take precaution that you file the declarations properly, whatever upload the relevant documents like license, certificate, approval, FTA, related catalogs on e-Sanchit while filing the bill of entry. And in case any queries are raised in e-Sanchit, file proper reply to the e-Sanchit, so that in future many PCA queries also could be avoided. I think this is what in brief I wanted to communicate with you. If you have any questions of this thing, I will try to answer you.
Thank you, Girish sir. Really great presentation we had here.
Thank you very much.
Sir, we in between, because of some connectivity issues, we had Mr. Om Prakash Agarwal who couldn't connect. I will just request him to, say a few words. Meanwhile, we'll just compile all the questions which have, come from members.
Okay.
So you can answer how many ever we should be able to maximum. We'll try and, put them. If there are some questions which we are not able to, because of constraint of time, we are not able to answer them right now. We maybe
You can mail
we'll
it to
put
me. I
forward
will
to you.
answer. If such a situation is there, you can mail it to me. I can answer on me.
Okay, sir. Once I'll just have Mr. Om Prakash Agarwal. Sir, good
Yes,
afternoon,
yes.
Om ji.
Good morning.
How
Good
are you?
morning, everyone. Good morning, Girish ji.
Good morning, Om
Good
Prakash.
morning, President and entire BCBA team.
Good morning.
Yes, thank you so much. And on the 84th Foundation Day, I give my best wishes to our association, all our team members, our president, and everyone. It has been a great association, and my association with our association has been great. And I must say, I learned a lot of things from the association, and I can very proudly say, whatever I am today, there's been great contribution of our association in making me whatever I am today. So I think that speaks of everything what this association has done for me and for all members. And I really, on this day, I give my tribute to all our founders who have such a great vision that they founded this association. This association has gone into 84th year. That itself shows that how strong this association is. And once again, my best wishes to President Kiran Rambia, Senior Vice President Dushan Mulani, all team members. I'm not taking name specifically, but I include everyone. And Girish Nadkarni, Mr. Girish Nadkarni has been a great friend of our CVs. And I was going through his presentation, a lot of things we came to know. And really, this is a great initiative from our association side. Once again, I wish all the best to all of us. May God bless all of us. Thank you so much. Thank you.
Thank you very much, Om sir. Thank you for enlightening us with your kind words.
Thank you.
Tej, if you have the questions, you could compile the questions. Maybe we can have them put forward to Girish sir.
Correct. So a very good, well, now afternoon to everybody. Since we've crossed the 12 o'clock mark, I must say we have a record number of participants, not only on Zoom, but even in YouTube. Nadkarni sir, it's always a pleasure, to hear you speak. Just for all who do not know, Nadkarni sir is a staunch supporter for BCBA training as well. He's always been there for us CBs who are preparing for the Rule 6 exam. And thank you, sir, for joining us on this very special day. We have some really interesting questions, which are, very technical in nature, and I'm sure your years of wisdom and guidance would help us through. So the first question is by Ms. Shraddha Agarwal, and we are taking that because ladies first. I would like to ask some guideline. How can a CB check over or under valuation of imported or exported goods to verify? So a second point is to verify import and export documents as per departmental guidelines, and what are the precautions that a CB should take before filing the bill of entry or the shipping bill. So the question, I can break it into two parts. Number one is verification of documents, as well as checking overvaluation or undervaluations. Over to you.
Basically, to be honest with you, the responsibility of the CHA, foremost responsibility is to file the documents based on the whatever import documents, commercial invoice, packing list, then bill of lading, etc., which is as provided by the importer. If you file those documents on the basis of this declaration, bill of entry on the basis of these declarations, normally no allegation against the CB could be made, because there are case laws also which very clearly have established that towards valuation or towards classification, the CB has in a way no responsibility, because there is no delegated legislation that CB should be doing this aspect clear. His job is facilitation, basically. So whatever import or export documents they are being presented to CB, they have to prepare the bill of entry and shipping bill in accordance with that only. That is the first and foremost. If you fail there, then God only saves. Rest, whether the value was overvalued for export or undervalued for import, according to me, it is not the criteria or nowhere the law mandates that the CB should be aware. However, if practical sense, if the importer comes to you for the first time, and if you know that he was earlier working with somebody else, then you can always fall back and collect that data from the importer by asking him to give all those papers. Because the third way is, there's an unofficial way which I cannot tell you on the public platform, to get the details from our customs records, because that is what basically forms the data. Data is with the customs authorities, and you can always have that data as to the previous clearances. If you have that machinery, then you can always check whether the value is declared correctly or incorrectly on the basis of data maintained by the customs authorities. The best way is to, if the new importer comes to you, you have to solicit the documents, past imports, bill of entries, which he cannot deny. But legally, there is no mandate that the CB is required to do all such background checks. But whatever bill of entry or shipping bill you are filing, that you have to file on the basis of the documents which are given to you by the importer or the exporter. There you should not falter.
Thank you so much, sir, for such a lovely and specific answer. Unfortunately, custom brokers are being made soft targets, as in the eyes of the law.
Yeah.
But nevertheless, when we have people like you behind us, I'm sure we'll get out of those matters very soon. So I'm the next question. I'm combining two into one because they are very similar. So So one anonymous attendee asks that the importer has been classifying documents under a specific CTH, and now after about 5 years, the SIB department has claimed that it should fall under a different CTH and is asking to pay additional duty. The second question is a very similar question. However, it says that it says that documents which are being assessed manually, not under RMS. However, customs has sent a notice that the HS code was wrong and a different HS code should be used, and it attracts anti-dumping duty. What should one do in these specific cases? So both relate to duty differences. One a basic duty and one attracts anti-dumping. Over to you.
If it is a case of inquiry after 5 years, then recovery of duty after 5 years is time barred.
Correct.
So and secondly, record maintain also as per the CBLR has to be for 5 years. So if anything somebody asks you beyond the period of 5 years, you can straight away tell him that as per the law, I am not required to maintain. I don't have the records. And in any case, there can be no duty liability fastened for import beyond 5 years.
Thank you so much, sir. So we'll move to another question that is there. Sorry. So Mr. Natarajan has said, what happens when a CB indicates import duty with exemption notification related to import duty when a BE is assessed at a different customs station? The officer at his discretion charges a higher rate of duty, and if the custom broker tries to recall the same, there is no guarantee of time taken or what the decision would be on the assessing bill of entry again. Is there a time limit for such responses?
See, basically, the assessment has to be done within time limit, because there is no time limit provided. If it is a live bill of entry, at least for delaying the bill of entry, under section 47, there are certain charges for delayed assessment. So that you can take up the matter with the jurisdictional commissioner of customs to come into the to help the assessment. There is no time limit, but yes, you cannot inordinately delay the assessment also. In such a situation, because if the assessment is delayed, the for delayed assessment, whatever penalties and charges are to be made, that becomes the responsibility of the importer. So you have to be proactive immediately the moment there is fishing queries or queries which are not sustainable. You have to seek the appointment with the higher authorities and sort it out. There is no time limit provided for us.
Thank you so much, sir, for the lovely answer as always. Mr. Hari has a very interesting question. What is the remedy available, or what are the remedies available where a tribunal decision applicable are not followed by the proper officer and the adjudicating authority?
See, as per the Supreme Court decision, hierarchy of the court has to be maintained. So if the Supreme Court if the tribunal has given you a relief, then unless and until there is a stay, if the matter is relating to tariff classification or valuation, there has to be a stay against the tribunal order from the Supreme Court. Or if the matter is relating to ITC, etc., there has to be stay. If the department is not agreeing, then there has to be stay against the Supreme order from the against the tribunal order from the High Court. If there is no stay against the tribunal's order, then you can file miscellaneous application before the tribunal for contempt. That is a legal avenue available if the commissioners are not implementing the tribunal order. The miscellaneous application needs to be filed before the tribunal. You can write a letter to the commissioner for implementing, give him 15 days. If he is not listening to that, then you have to move the tribunal again for contempt of tribunal's order.
So we'll take a couple of more questions. We have a very interesting question from a custom broker just received. So assuming that the shipment has been cleared, the shipment was to be cleared under a participating government agency requirement, like let's say a plant quarantine or animal quarantine, etc. However, that process was not completed. In that case, if there is a post-audit query, does customs have the authority to, recover? Well, since there is no question of recovery of revenue in those aspects, what is the role of the custom broker, the customs, and what is the stand that the participating government agency can take in terms of non-compliance?
See, to be honest with you, audit is basically audit's role gets confined to differential duties. A matter where import trade control violation has taken place. Generally, audit department may not get into this, because what happens is, in such a situation where a particular, say, insecticide act is applicable, there is some insecticide which you have cleared without getting clearance from insecticide board, and in such cases the goods are liable to confiscation under section 111D. But for that reason, the goods are not available for confiscation. But penalty proceedings can be initiated if it is linked or if it is proved that these particular goods were cleared without following the, in the absence of some document which was required as a valid permit for clearance. Proceedings can be initiated, but generally such proceedings are initiated by SIAB or DRI. It is not that once you are cleared, you are scot-free. But audit generally does not step into such cases, but surely SIB or CIU or DRI can step in, and post clearance they can initiate action against you. Your exposure to law continues.
And does it continue for the same period of 5 years, or does it is it exposed beyond 5 years?
No, 5 years in such cases is not applicable. The 5 years period is for only for the recovery of duty. This is not concerning the recovery of duty. This is the violation of the import trade control in a way. Because section 11 is violated, it will lead to section 100, because certain permits are required as, by the for the clearance of the goods, which permits you don't have those permits. It's like import license which you require for clearance. You don't have import license, you have cleared it illegally. It is a case of clearance of illegal goods.
Understood.
In such cases, your exposure continues for any number of years. I should say, any number of years. You cannot, nobody can bar you. But what happens is, normally if the show cause notice, supposing you clear the goods in 2010 and you are issuing show cause notice in 2020, such type of show cause notices are thrown out by the courts by saying that beyond 7 years or 8 years, where you sleeping, you can't investigate such cases. But then High Court has the power to stay such proceedings, not the normal person. You have to go to the High Court. But then you are going before the High Court not with clean hands. That you should bear in mind. So many a times when you are approaching High Court without clean hands, High Court gets upset in such situations. So you should avoid getting into this.
Thank you, sir.
Exposure continues. That is not barred by limitation. That will continue.
Sir, I'll ask you. I'll take just two more questions, simple ones at that. So one question is that if now that documents are uploaded in eSanchit, is the custom broker still required to maintain records, or the customs would check in the uploaded documents in eSanchit if any query during post clearance audit or any inquiry? I would just like to supplement this question, sir. Technically, we are uploading documents to eSanchit where we have a IRN and DRN number. Now, we may or may not have records on our premises or our cloud space electronically, but we may even download, or do we have the ability or option to download, because you can access IRN and DRN data for at least as of now it's being told an unlimited period of time. So would one require to maintain documents electronically, or would one require to maintain documents which are there on eSanchit? Is that sufficient?
I think is whatever documents are required for the purpose of assessment of customs duty, all such documents have to be put properly in eSanchit.
Okay.
You may keep copies of that for your record for the period of 5 years.
Thank you, sir. The last question before we hand it over back to Neerav. And it's a very interesting question because PCA has been, it's been a big challenge. In case of a consultative letter and there is an issue of a short levy of IGST paid, the importer is asked to recall and reassess the bill of entry and therefore is paying duty on a manual challan because customs has denied the same. And they issue a SCN and charge fine penalty. So in that case, is IGST claimable or not?
I will come back on this issue because this is a bit technical issue. But if because I need to consult some IGST expert, I don't have much expertise on IGST credit matters. But I understand that if you pay manually, there are some instances I know that if the IGST, differential IGST has been paid manually, even based on challan, the credits have been considered.
Okay.
I think you can consult the Senior Vice President, Mr. Dushan Molani, because he will have some light to throw on this. This is extremely technical issue, which I don't think I will be able to throw much light on this. But I shall come back to you on this issue after consulting books or something.
Agreed, sir. Thank you very much, everybody, for the lovely questions. We have some more questions. However, due to shortage of time, I would request if you could just send an email to BCBA. We will forward those questions to Nadkarni sir, and we will come back to you with the answer. Once again, everybody take care, stay safe, and thank you very much for signing on. Nirav, over to you.
Thanks, Tej. Great questions and discussions, and there are many more. Girish sir, due to paucity of time, we will be forwarding these questions as which are there on the Q&A that we have received. We've noted all of them, and we request you to provide answers, many relating to systems and many other things. But we will then forward it to our members. We also have a few who had wanted to speak. Because I think we have limited time, we'll just have one member to speak in front, and then we can probably proceed with the vote of thanks. Tej? Okay. So we have Mr. Vinod Sharma. Vinod sir, hello Vinod ji.
Yeah.
Okay.
Yeah. First of all, dear President Kiran Rambia ji, all committee members, congratulations for celebrating the 84 years. The way you are working, it's a really commendable job for all of you. 84 years is a long, long period for anybody to work in the same organization. You will believe that 70% of us would not have taken birth in those areas, right? And we born and brought up in that period under their guidance. And kudos to past president also passing on the same baton, same legacy to the next president and EXCOM. The dynamics of the working pattern for any president and committee has totally changed. The way the BCBA is supporting all members, we are working 24/7, right? The other institution, should have worked 24/7, but we are working 24/7 to support our all members. Whether it is a Sunday or Saturday, every year committee member supporting the members to complete their tasks, right? The past 10 years, you have supported a lot in case of issuing the passes, in case of renewal of the custom broker licenses. It's a really, really commendable. You are doing a great job, and carry on the same, and wish you all the best for the incoming years. Thank you very much, sir. Thanks for giving me the opportunity. Thank you.
Thank you. Thank you so much, Vinod sir. Thank you. Sir, we are just about 5 more minutes. Paresh sir, I would request you to give the vote of thanks so we can sum up the session.
Yeah. Thank you, President. Thank you, Nirav. On behalf of BCBA, it's an honor and a pleasure to give vote of thanks on this occasion. On this auspicious day of our Founders Day, I would like to take this opportunity and thank all our Board of Advisors, past presidents, seniors, who have been the real source of inspiration for all of us. Dear sirs, it is because of your guidance and support we have been able to achieve this milestone. I would request you all to kindly keep us guided and bless us in our future also. Our special thanks to Sri Girish Nadkarni ji, who has been part and parcel of the CB fraternity and a very well-known face in our fraternity. Thank you, Nadkarni ji, for sharing all your wisdom, thought, and your valued guidance. Means a lot to us.
Thank you very much.
On this very important topic of past post-clearance audit and how to protect ourselves for the future and not to get afraid of the threats or other type of misguided information provided. So thank you, Nadkarni ji, for really sharing the wisdom to our fraternity. I'd also thank our President, Kiran Rambia ji, and my colleagues in Managing Committee for organizing this extreme important seminar for our entire fraternity. Thank you. I would also like to thank the wonderful audience and our members of fraternity, because without their support, this wouldn't have been possible. So I take this opportunity to thank each and every member of our fraternity for supporting us in serving you. Thank you and take care.
Thank you.
That's all, from my side.
Great. Thank you. Thank you. Thank you, Paresh sir.
Thank you, Nirav, for extending your extraordinary help. And thank you
I
all
think
for appreciating my efforts. Have a
Thank
nice
you.
day.
Thank you. Thank you, sir. Thank you.